Welcome to class 27 of Secretarial practice. In this class we are going to end with the third chapter. So the last topic of third chapter is lifting of corporate veil. So what is this lifting of corporate veil? The principle of veil of incorporation is a legal concept that separates the personality of the corporation and the personality of its shareholder and protects them from being personally liable for the company's debt and others' obligation. So what does it mean? So liability of company is, or the personality of company is different from the personality of the shareholders or the owners, directors or whoever working there. Okay, so that we call it as veil. So what happens when this corporate veil is there? So the company is protected from the outsiders. Okay, so for example, the company has taken the loan from XYZ company and it fails to repay it. So the XYZ company cannot come and collect it or recover it from the company. So because company is a separate legal entity, but it also cannot collect it from the shareholders or the directors who are there, because it is said that the personality of corporation is separate from the personality of its shareholders, and hence it is and protects the shareholders from being personally liable for the company's debt and other obligation. So this we call it as corporate will. Okay, so since an artificial person is not capable of doing anything illegal or fraudulent of corporate personality, so might be removed to identify the person who are really guilt. So this is known as lifting of corporate will. So we have understood corporate will, right? So corporate will means you are going to protect the company, or we can say the whoever shareholders are there, whoever directors are there, so those persons are protected with this doctrine. So but here lifting of corporate veil means, so lifting that or tearing or just destroying that corporate veil with legally. So we can say, since the artificial person is not capable of doing anything illegal, so we call the company as a artificial person or a legal entity, we can say. So can an artificial person make anything illegal or fraud? No, right? So there should be some person who is going to do that. So in such case, what you are going to do, you might have to you have to find out who is the person who have made or who is actually made the guilt. So that person will be made liable. So this we call it as corporate or lifting of corporate will. Okay, the next chapter deals with the management of company. So what does this says? Okay, so first it says about your directors. So director say, what does the director mean? Any person occupying the position of directors by whatever name is called as directors. Who are the directors? So the company's act says that any person who is going to act as a director or perform the duties of director, so will be called as director. So which, by irrespective of whatever name is called. So his name may be anything. Okay, but when he is going to perform the duty of directors, so that person will be called as director according to the company's act. Okay, so why directors are needed? So we know company is artificial person which is created by law. So it doesn't have any physical existence. So what happens here? So when it is, or when it doesn't have the physical existence, or when we call it as an artificial person, so it cannot act by itself, right? So it cannot act by itself. So whatever performance it have to do, it should do through the natural person. So the person through whom it acts, we call it as directors. Okay, so company through what it acts, we call it as directors. So I repeat, being an artificial person company cannot act individually, or company cannot act by its own. It is supported by some person, or behalf of company there are some person who are going to work, and those persons are called as directors, and the directors of companies are collectively known as board of directors, or simply the board. Okay, so what does it means? So when there are many directors, 1 2 3, so all three together we call it as board of directors, or simply we call it as a board. Okay, so we can say that no body, corporate, association or a firm shall be appointed director of a company. Only an individual shall be appointed as one. Okay, so what does it mean? It is to be remembered that no body, corporate, association or firm shall be appointed director of a company. Only an individual shall be appointed as a director, which means the company, when we treat it as individual person, the company itself we cannot take it as a director. So there should be individual, there should be a person there to be appointed as a director. And what is the importance of directors here? So the director is going to have a very important position in the company. So in the administrative pyramid, okay, so they enjoy an access, or they are going to enjoy and exercise the wide powers of management. So they are responsible for what? Determining the general policy of the company and carrying out or carrying the business of the company in their best possible manner. So there are some provisions relating to directors. Okay, so what are the provisions? So first says the number of directors. So number of directors, it says every public company, so other than the public company which has become or become as such as virtue of section 43 or 43A. So here every public company must have at least 3 directors, and other than public company, so private company, they may have at least, or they must have at least 2 directors. Okay, so what happens here? This is a statutory limit. Okay, or we can say, sorry, not statutory minimum thing what we should have. So public company should have 3 directors, private company should have 2 directors. So subject to this statutory minimum, the articles of company may fix the minimum and maximum number of the board of directors or directors of its board. Okay, we know all the directors collectively called as board of directors. So here it says, taking this statutory minimum into consideration, the article of company is prepared, and the articles of company is going to state how much minimum you should have and how much maximum directors for your board you should have. So with this limit, or whichever limit fixed by the article, the company may increase or reduce the number of its directors by passing the ordinary resolution in the general meeting. The next it says provisions relating to directors, which means the continuing part of the directors, number of directors. So private company, if it is a subsidiary of public company, and any increase which is beyond the fixed limit of the article must be approved by central government. Okay, so as I have told you, taking the statutory minimum of the Companies Act, they are going to make the articles, and in the articles they are going to fix the minimum and maximum number of directors, and they can increase or reduce the number of directors by passing the ordinary resolution in the general meeting. So now in case public company is holding company, private company is a subsidiary company. Okay, so as per the rule, public company must have 2 directors, sorry, private company must have 2 directors, public company must have 3 directors. So what you are going to do now? So private company is a subsidiary of public company. So in this case, any increase which is beyond the fixed limit or limit fixed by the articles. So whatever article is there, if you are going to increase or go beyond the articles which is what is been given, you should take the permission of central government, and such an increase must be, or it must be up to 12. Okay, so increase become beyond if it is disapproved. Okay, so only when you have approval from the central government you can increase it by taking the permission of central government. So here central government going to give you the approval, and when the approval of central government is not needed, so when the total number of directors are less than 12. So the next is appointment of directors. So the first director. So first director is appointed at the time of formation of the company. So who is going to appoint? The promoters are going to appoint. So they are generally select and secure the consent of the prominent person to act as a first directors of the company, and their name will be mentioned in the articles. Okay, so and they are going to hold the office until the directors are duly appointed in the first annual general meeting. So till the first annual general meeting you are going to have the director. So that director are called as the first directors. Okay, the next is subsequent directors. Who are subsequent directors? So subsequent directors are the directors appointed by the directors. Okay, so they are appointed by the subsequent directors are the directors which are appointed by the company in the general meeting. So in public company, at least 2/3 of total directors will retire by rotation, and only 1/3 can hold the permanent directorship. Okay, so what does it mean? So it says in case of public company, at least 2/3 of total directors will hold the office, that is retire by rotation. In other words, of a total number of directors, only 1/3 can hold its permanent directorship. So what happens here? Suppose you have 3 directors, 2 will be retiring by rotation and 1 will be the permanent director. Okay, so however the articles may provide for the retirement of all director at the every annual general meeting. So what is interesting is, in private company all the directors can be permanent if the article so provides. Okay, so if it is mentioned in the articles of private company, so they can have the permanent directorship. The next is appointment by directors. The first is your additional director. So additional director means the board of directors, if an article permits, may appoint the additional directors. So such additional directors shall hold the office up to the date of the company's next general meeting. Okay, so if the permission is given by the articles, the board of director can appoint the additional director, and that director is going to hold the office only up to next general meeting. The next is casual vacancy. So if the director office remains or falls vacant, you have to fill that. So what you are going to do, if the office of any director falls vacant before the expiry of the term, the resulting casual vacancy may be filled by the board of the directors at the board meeting, unless the articles of the company prescribe the different procedure. Okay, so what happens? Until and unless the articles of the company is going to give you the different procedure to fill the vacancy, the board of directors can fill that vacancy. So to fill the vacant before the expiry term. The next is alternate directors. The board of directors and if the articles permits, the board of directors may appoint the alternate directors where the original director is likely to be absent for the period of 3 months or for more than that. So the state in which the board meeting are normally held. So when the board or the original director is absent for 3 months, so you have to conduct the meeting. In such case, you are going to have the alternate director. An alternate director shall vacate the office when the original director is going to return. The next is appointment by third parties. Okay. So appointment by third parties says that if the article permits 1/3 of the total number of directors of a public company may be appointed by third party on the non-rotational basis. So we have said, so when there are 3 persons as a director, 2 are retiring by rotation, 1 is not going to be retired by rotation, and that 1 person is appointed by the third party and they are not going to retire by rotation. Then the next is appointment by central government. So appointment by central government means in case of any mismanagement, the central government may appoint any number of directors to protect the interest of company, shareholders and the public. Okay, the person so appointed shall hold office for the period of 3 years only. So if it may be noted that the person appointed by the central government need not hold any qualification share, nor need he liable for retire by or to retire by rotation. Thank you.